Hey everybody, this is Ryan McClanahan with historythroughcards.com. Hope you're all doing very well today. So I quite recently came across the Panini America vs. Fanatics lawsuit, and I know that a lot of other YouTubers or hobby influencers or whoever have spoken about this. Even Rich Klein, who actually gave me the lawsuit in its full glory. So Rich, thank you so much. I greatly appreciate that. Um, this is 56 pages. For me, it's kind of like waking up on Christmas and finding all these gifts under the tree. I I'm going to come at this not as a collector. As you can see, I am a collector in the background there, but I'm actually going to come at this as a journalist and someone who specializes in the law. I actually kind of study legal cases, especially when they have something to do with the hobby or sports cards or how sports cards were issued. What a lot of people don't really understand is that, especially with your tobacco cards, they were formed through legislation and they died through legislation as well. And I'm sorry about that, guys. Cars happen. Um, Let me see how long it takes for them to take off. Jeez, go to a mechanic, will you? Get that thing checked out. Hey, make like eggs and beat it, will you? Trying to do a podcast here. So Panini has actually hired David Boys to represent them, and I thought this was a pretty smart move, to tell you the truth. David Boys represented the government in 2001 during the Microsoft antitrust case, in which Microsoft was trying to eliminate their competitors' browsers, among other things. And that case actually took from like 1995 to 2001. And then they didn't exactly break them up. Louis Brandeis had always said was that you have to deal with monopolies individually and make sure that uh, the certain monopoly that you're going after is easy to break up. Some monopolies are so difficult to break up that they actually might cause more harm than good. And in the American Tobacco Company case, this is actually what had happened. I'm not going to go too far into it because I am writing a book about the American Tobacco Company and their case. I will tell you that it took a special counsel to or a justice, a special justice to get involved and to try to figure out what was the easiest way to break up American Tobacco Company where it didn't hurt other companies or individuals. And sometimes this actually happens. We don't really know what may happen when a company like say AT&T, uh, they were a monopoly for a long time and they were never broken up because they didn't know how to do so. And I think in about 1957 they started looking into this, but by I think maybe the 1990s or so, or the 1980s, Ma Bell and her company were broken up. I'm not sure how successful that was, but they were broken up and it took like I think 40 years or so. Anyway, in this case though, we do have certain other monopoly cases to fall back on in regards to Panini versus Fanatics. And again, I haven't read the Fanatics countersuit, so I don't know exactly what Fanatics is alleging Panini has done. In this case, though, we do have precedents to go on. So what I think I'm going to end up doing is just going through what Panini is alleging here and kind of like go through other court cases as well that have to do with the hobby. Now, I do have a lot of notes here, and I'm going to go through my notes and we'll see what happens. I'm actually not going to talk any legal jibbity jive because I don't want to confuse you guys, and I know that's like my first language, jibbity jive, but I'm gonna keep it to English this time. half English if I can. And I always tell people that, just because you're not a lawyer doesn't mean you cannot read and understand the law. That doesn't mean to say that you should be your own lawyer. I've always said this. If you're ever in a court case or anything like that, um, do not represent yourself. I represented myself in one case and I got very lucky. Judges and courts, they don't like this at all. And so don't do it. Only a fool has a client for himself, or so the story goes. But I agree with this. Don't ever represent yourself in a court case. I just got very lucky when I did so. I don't really like to speak in Latin terms when I'm reading or talking about legal cases, and I came to this conclusion that it's not very helpful. Um, and the reason why is because of what I've seen in the hobby. If you're in the hobby for any certain amount of time, you start to pick up certain acronyms and certain phrases that only hobbyists use. And this is also true in the military as well. So there's a lot of acronyms in the military. And one thing I've found in both of these cases is that it can easily alienate other people who are not in either the military or in the hobby. And you could really kind of feel like an outsider. So whenever uh, lawyers they write or they kind of speak in I guess legal terms or Latin terms. I know it's kind of a shortened abbreviation in itself. Latin is great for English and being a writer, but it is not something that's used, I think, on a daily basis for a lot of other stuff. However, I thought that maybe speaking in a regular layman's terms would be easier. So I'm going to kind of ditch all that, and I'm not actually going to read a whole lot of the case here, not even word for word. There is legal precedent here, I think, in Panini's favor. And the hobby is really kind of interesting when it comes to the legal side of this because, as I said before, a lot of cards and companies that issued the cards and even the players have run into legal challenges or cases. And in one particular case, the T206, that was born through legislation, and again, it died in legislation. We don't actually realize just how much legislation has played in our hobby because for a lot of people it is just that, a hobby. But for these other companies, the card manufacturers, it is it's very serious business, and it all leads to money. And so I'm going to kind of tell you a little bit about Panini, which I was not fully aware of. It's only because I read this 56-page case that I'm more familiar with Panini now than I was before. So Panini, they actually go back to 1960 in Italy with four brothers. First, it was Benito and Giuseppe Panini, and then in 1963, Umberto and Franco joined the company. They started in trading cards in 1968 that I'm aware of. They could have a few prior to that, but in 1968 they came out with their Cantonini or Cantini. Me, I don't know these words. Jesus. Anyway, um, and that set was it was filled with music stars and bands from the 1960s. And this is actually a really great set because it has everything from the Doors to Cream. I think Ray Charles is also in the set, and a few other Stevie Wonder. I did see Stevie Wonder. It's a great set. There's a lot of other names that I'm not familiar with because they're Italian. But anyway, in 1970, they came out with a football set, or AKA soccer. So That's also very popular as well, and both of these sets are very popular. And I think the 1968 and 1969 Cantonini, those are becoming more and more popular, and I think they will continue to be just because you have so many stars in that set. And again, I'm a huge fan of the Doors, so that would be the first one I'd want to grab. Anyway, and they are becoming actually more expensive too, as I am noticing. In the 1980s, they came out with their smash hits, and this is actually awesome because they have bands that I grew up with, and the Thompson Twins, huge fan of them, and Van Halen. Again, I'm a huge fan of Van Halen. I'll probably die listening to Van Halen music, which isn't bad. So anyway, unless I go deaf, which I'd rather go blind than deaf, to tell you the truth. Um, if I lose any of my senses, it would suck. But I think I could probably do without taste, especially when my girlfriend cooks. Oh, I didn't say that. Anyway, let's continue. So they entered the U.S. market in 2009, and it was claimed that their anti-competitive conduct to monopolize the U.S. market was happening. Panini currently holds an exclusive license with the NBA Players Association through September 2025, and they also hold exclusive licenses with the NFL Players Association through March and February 2026, and with Major League Soccer or football. And I think that Panini's main concern here is the licensing, the exclusive licensing, in fact, because Fanatics has had or will have a 20-year exclusive license with the majority of uh, sports leagues. And so uh, they say uh, in their case here, Fanatics began its anti-competitive conduct by secretly securing long-term exclusive licensing deals with the MLB, NBA, their players' associations, and the exact details are not divulged. These deals are exclusive for 10 years, and actually, in I think some cases, 20 years. And uh, that I don't think has ever happened before, unless you start looking into Marvin Miller and his deals with Tops in say 1966. Well, he was the first major league players rep, I guess, and he was from the Steel Workers Union originally. He's actually he's in the Hall of Fame. He got in, I think, in 2019. I'm not sure how I feel about Marvin Miller, to tell you the truth. There's on one side he he did a good thing for the players, and in fact, let me see if I actually have this written down. If not, I'm gonna have to go by my stupid memory. No, okay. So licenses, we know them today, were the result of, again, Marvin Miller forming the Players Association in 1966. There were other Players Associations prior to Marvin Miller. I think Robin Roberts and Bob Feller and I think Ted Kluszewski formed a Players Association prior to this, but it was underfunded, and so they quit. And I think at the time, Bob Feller was the president of the Players Association that he formed, and he was an insurance executive after his retirement. So that's probably why he was the president, because he was highly respected as a player and fairly smart guy too. Anyway, Tops, they changed the terms of their conditions between Joel Shorin and Marvin Miller. And at the time, The contract from Topps to have the players on their cards was $5. Now that doesn't seem a lot today, and well, it isn't. But if you think about it, it's the equivalent of $47.10 in 2023, and this actually jumped up to $125 through Marvin Miller, and that is the equivalent of $1,177.12. Topps paid no royalties prior to this, and that agreement was settled in 1966 to have a royalty check for the players. Began the official sports license, and so prior to this, you have something that's completely different. Bowman and Topps had they had their legal cases in say 1949 through 1953 that's called the contract wars, and it's all about who has rights over what player. A little more involved than I just told you, but some players were actually having signed both contracts, exclusive contracts, by the way. And so there was a lot of confusion from both sides as to who had what player signed to an exclusive contract. And one of the most famous deals was that of Ted Williams in 1954, where he signed an exclusive contract with Topps to have two cards printed in that set. And I think Topps had paid Williams like $100,000. I think it was a very, very large contract, and Bowman actually printed Ted Williams' card in 1954, and that was pulled from production. And so you have a few other cases like that too. Obviously, the big one that everyone thinks about is Honus Wagner and the T206. That was never brought to court. There was one case, a guy named Harry Porter, who was an Olympian in the 1908 London Olympics, who had a card printed from the T218 set, and he said that he didn't give permission to have his likeness on a card, and he sued the American Lithograph Company, who was printing the cards for the American Tobacco Company. And at the time, he was to be given $10, which was the equivalent of $300 in 1910. He lost his case, and I'm not entirely sure why he lost his case. And the other thing is, he was a gold medal Olympian, and so he actually got banned for receiving money. It's a different story, but it kind of goes to what's going on here today. Very, very interesting cases. Again, Honus Wagner didn't bring the American Lithograph or the American Tobacco Company to court. I don't think he needed to. I think he just needed to write a letter or have a lawyer write a letter to the company saying, knock it off. And he did have a legal right in 1909 to actually do this. And that goes back to the 1903 Robinson case. And Miss Robinson, Abigail Robinson, I had actually mentioned this in maybe a few other videos, but she's actually one of the first right of privacy cases in the country. And now she actually lost her case too, because the court, the lawyers, the judges didn't understand what was going on with this new technology called photography, and the right of privacy really wasn't a thing in 1909 or even 1903, because for a judge to understand really kind of like what's going on within this new technology, there has to be precedence. There has to be something prior for the judge to say, okay, listen, there is something going on here that we can kind of attach to. And so she lost her case because they didn't understand this. After that came the 1903 right of privacy statute from New York, and from that came the 1909 Copyright Act, and that's really where we find for the first time that each sports writer from every city who had a baseball team had to get permission from the ball player to have his likeness on a card. So that's where that comes from. So it actually says in this case right here that sports cards have two key requirements: a license from a league, and B, a license from a league's player association for use of the player's likeness and their signature and their name. And so that's where all that came from, was through the Robertson case and then everything I just spoke about. And it is quite important. The interesting thing too, which is not really I think a component of this case, is that the right of privacy and uh, that is different for each state, and having a sports player or a personality, a famous person, if you will, having their likeness on a card or whatever, that could be different for every single state. And what happens? Does it go to do you have to ask their estate or the person themselves? If the person is alive, that's one thing. If they're a public figure, it may be different than, say, if I have my likeness on a poster that I didn't agree to, can I sue? Yes, I can sue. Can a famous person sue to have their likeness taken off of that same poster? I'm not entirely sure. Again, it would depend on certain factors, and the times for Sullivan. Again, it's a law from 1964, which I think needs to change or be amended or maybe just scrapped altogether. But that's where, again, I think that's where that comes from as well. Um, but it's different. So a lot of people say that the right of privacy doesn't exist for sports personalities or famous people because they're the ones who put themselves in that position. And this was actually challenged by Johnny Mize, of all people, in 1941, and he took Gum Products Inc. to court in 1941 when he saw his likeness on a double play card. And I wrote a lot about that. I still haven't seen the transcripts from that case or the stenographer's notes. I don't think that they know where those are. I think they're lost, which is really interesting because that's one of the first court cases that I'm aware of, from a player taking a company to court, outside of the Porter case from 1910. And again, Harry Porter is he's not well known. He's not definitely not as well known as Johnny Mize. But Johnny Mize lost his case as well. It took about a year or so. It's changed quite a bit actually since Johnny Mize's day. But he was really, I think, one of the first modern players to take a company to court because he didn't want his likeness on a card. And you definitely see this because he's got one card in 1936, the National Chicle, uh, the the pastel premium, and then you don't see him on another card until 1941 with the St. Louis Browns and Cardinals team sets. Now they actually mentioned this as well, and I thought that was kind of interesting. They didn't actually mention Johnny Mize or anything like that, but they did mention that the characteristics have changed a little bit if it's a team issue. So they do actually mention this. It says neither an individual league nor has an individual player association has or could itself produce and fully license a trading card. I don't entirely think that this is correct. Again, you have a lot of team issues, especially from like say 1910 through the 1930s and 40s. You have a lot of team issues, but they here are talking about the Players Association producing cards, fully licensed cards themselves. And I heard Victor, the rookie card specialist, who he has a really good channel, which I really enjoy. Like he's always talking about fully licensed trading cards and rookies. He's got some pretty good points, I think. He really kind of dives into this stuff. I'm not sure that he actually dove into this particular case. The thing that I think is kind of interesting is when he's talking about what is a rookie. I think he may be talking about modern cards that are distinctly different than vintage cards. Now, it's always interesting to hear other people and collectors say what or define what a rookie card is. I may be inclined to agree with Victor, where you have to separate modern cards, their rookies, from vintage. Usually, it used to be that a rookie card was the first card of a player, the first image, and so it didn't really matter if it was a nationally distributed card or a regional card. That card was the first card or the first image of that player is his rookie card. I'm not entirely sure or convinced that that is the case for modern cards because there's so many rookie cards out there. I find it very confusing. And I'll tell you a real quick story about this. So um, I was at a show maybe in February or March, and it turned out to be all modern cards, and my jaw dropped. I walked in there and I was immediately taken aback by all the cards, and I didn't know any of the players because I haven't watched sports in the last 20 plus years. Really, I've seen a little bit here and there, but for the most part, I don't know any of these players, any of these new players. I know the old players. I just don't know any of the players that have played in the last 20 years. So that to me was really eye opening, and I was very overwhelmed. And the first show, I walked out just kind of in shock, really. And second show, I came back and I was visiting a buddy of mine who was there who I haven't seen since really high school, and he was a card collector. And so we walked around a little bit, and I calmed down a little bit, and I found I think I found yeah I found this card right here, the Joe Montana. So I really love this card. This is one of my favorites. I've always wanted this particular card in my collection, but again, I wasn't willing to buy a raw copy because it is one of the most forged cards of the 1980s. But another reason why I really enjoy this particular card and set is that it reminds me or represents a very important year in the hobby. And 1981, Judge Clarence Newcomer came out with his decision that Topps was a monopoly, and so there are cases in the hobby that have to do with monopolies, and this is one of the biggest. In fact, that case, I actually wrote a pretty lengthy article on this, and in this case, in 1981, when he came out with his decision, he was actually going back to the 1960s, and I think in particular, Flair's 1962 through 1966 Federal Trade Commission case. And so he had read this, and I read this as well. And I'm actually going to have an article on this with the 1963 Flair set. Very underrated set, a very easy set to complete for the most part. And it's been a set that has been fairly cheap too, historically. So the 1963 2006 decision from the Federal Trade Commission said that Topps did not have a monopoly based on the contracts, most of which Topps had because they bought out Bowman in February of 1956. And so Bowman actually had the majority of ball players' contracts from like 1949 or 48 through in 1955, not Topps. But once the Topps obtained Bowman, they got all of their products, their mock-ups for future cards, including the 1957 Topps football set, which was supposed to be Bowman's baseball set for 1956, and they also got all the players' contracts. So when Fanatics acquired Topps for $500 million, and I think it was January of 2022, very recently, by the way, it says according to Panini that Topps had no chance to continue as a company, and according to Panini, Topps was really kind of like one of the only independent companies out there, or one of the very few now. There's Upper Deck, which is independent, but this is really where it gets, I think, very confusing for, I guess, the outside, if you will, people who are looking at the hobby who don't really know a whole lot about it. Say maybe a judge, for example. There's so many products out there that it looks like it could be from a multiple grouping of companies when in fact it could be just one company. So in Panini's case, they had 22 products for November and 18 for December. This is also very interesting too because you see over, say, the last 30 years, sets have grown. So, in 1985, you only had Topps, Flair, and Don Russ. Over the last couple of years, you've seen maybe like one company have like 4 sets, another company has 6 sets, another company has like 8 or 9 or 10, and this kept on growing more and more and more. Again, Panini had 22 sets or 22 products, and they say that they actually have over 100 sets that they have issued. That's a lot. That's way too many. A lot of, I think, concerns from collectors is that Panini's products are really cheap. I don't know if they're cheaply made or there's just so many of them that everyone has the chance to buy a Panini product, which again, if you really want to get into the hobby, that's great. For someone who's an investor, that might not be so good because their cards will never gain in value because there's so many of them. We're going to deal with this for a long time. It's the junk wax era 2.0. With the Topps buyout, Fanatics also bought a company called GC Packaging LLC, and it's the manufacturer for Panini's products. And according to Panini, they're saying that this is a violation of the GCP contract with Panini to have their competitor essentially buy out the majority of GC packaging. So with this, actually, Panini said that when they had 22 products for November and 18 for December, what happens is normally a product plan is scheduled for 34 weeks, and that's throughout the year. They have to have so much time planned and everything set together to get these cards out. And GCP gave Panini only 10 days notice, saying that they had quote unquote shifted priorities, resulting in only 12 to 16 product releases. They may say actually that that was planned through Fanatics. I don't know. There's a lot of evidence here that we're not privy to. So just keep that in mind that we don't have all the information here, even though there's a 56-page report we just or lawsuit, I should say, we don't have all the information, and we won't because we're not a part of the civil suit. I would love to be a fly on the wall for this one, to tell you the truth. Other things that I've noticed that were really interesting too here. So they say the relevant product markets are limited to newly issued trading cards created by producers and sellers like Panini. In industry terms, this is the primary market, which they're correct, distinct from resale or secondary market, which would be really your vintage market too. So this really doesn't affect me in any way, shape, or form unless, say, Fanatics or even Panini buy back all of the vintage cards that you see in the back here, which is very unlikely. However, as Dustin, the personal sports card dad, has really kind of always maintained, is that every modern card turns into vintage eventually, and that has its own problems associated with that. Not a problem really, but if you're spending a lot of money on modern cards, A, you're taking a gamble, but B, we've seen this happen before, where a lot of the players today that are being talked about and collected, are they going to be collected 20, 30 years from now? Are they still going to hold the same value? Most likely, the answer is absolutely not. All you have to do is open up a bucket from, say, 1985 or 86 or 1993, and you can see the same players in the same cards and see what they're going for now to get a good sense of what the modern market is going to look like 20 to 30 to 40 years from now. What they also said, which I thought was really fascinating here, is they give you kind of a window into how these cards are produced, and not really giving any trade secrets here, although they do go through some of the materials needed to issue our sports cards, and um, it says specifically on number 47. So there's all numbers, right? It's all numbered 1, 2, 3, 4, right? So it says number 47. The relevant markets also have high banners to entry, including because of the need for licenses, the existence of exclusive licenses, the duration of licenses, and that's really, I think, their bread and butter is in this case, is the exclusivity of their licenses. And again, why these licenses are 20-year exclusive licenses. That's something that the judge may actually side with Panini on. But it goes on to say specialized high-tech manufacturing requirements and the need for skilled workers such as card designers, program designers, product developers, athlete acquisition managers, and specialist print managers. The technology in printing has really gotten better and better over time, especially since, like, say, 1909 when the T206 came out. In 1909, 1910, when those cards were brand new, that was new technology back then. There really wasn't anything like that before. I mean, obviously, you had the old Judge from 1887. You didn't have anything like the T206, and it was all over the place too. You couldn't escape those cards. However, uh, printing technology always changes. There's a huge difference between the way this card was printed and the way, say, this card was printed right here. A lot of it hasn't been divulged, really. I don't know how some of these cards are actually printed. To me, it's like magic, and it's spooky too. But it does take a specialized company to actually do this. Bowman and Topps were actually sharing the same company to ship their cards. It was Connolly Containers, and that was in the 1950s. And I believe that Topps actually acquired Connolly Containers later on. Both of those companies were actually using the same shipping company, and they actually might have been using the same printer as well. So most companies prior to, say, 1982 or 1985 were actually printing cards via third party. Bowman never printed their own cards. They had Zabel Brothers to print their cards, and I think maybe one or two other printing companies, which I can't figure out. And then I believe Zabel Brothers, or at least Baltimore Printing Company, Lord Baltimore Printing Company, printed Topps cards up until 1982 when that company went out of business. Topps actually started printing their own cards. Leaf always printed their own cards. So they're actually one of the very few companies that actually did print their own cards. But for the most part, most card companies would have a third party to print them. Today, though, card manufacturing is it's so highly specialized that you need a particular printer to do this. I wouldn't know how to do this, but there are certain people who actually do. I think it's obviously it's on a computer where before you had specialized equipment and old school, right, to get this stuff done, and stuff that we don't use anymore for the most part. But again, there are certain time tested and true methods to get a card printed. But again, we do use computers more and more often to design this stuff, and then the specialized printing needed and the people. So that's the most important thing is the people. And what Panini is saying is that Fanatics is poaching their employees. This isn't really something new. American Tobacco Company was accused by the government of poaching employees as well, and basically starting riots in one case in another company's manufacturing room. It's a whole thing, and it's all described in the American Tobacco Company's report, where the Bureau of Corporations report on the tobacco companies, American Tobacco. So we do have, again, precedents for what's going on here, and I'm pretty sure that their lawyer knows all about this stuff going after Microsoft as well. David Boies, again, he was the lead counsel for the government going after Microsoft, and again, in that case, uh, Microsoft was trying to get rid of their competitors' platforms, among other things. So um, I think he was a very smart decision to have him as a lead counsel. And in fact, in the Microsoft case, you had 35 other law firms in on that. So that again, if you guys have time, you can look into that. I also saw it too. There's some other very interesting things. The exclusivity of the licenses. Again, as I say, that one is probably going to be the main catalyst for Panini's argument for monopolization. I've gone through the Sherman Act a couple of times here. The Sherman Act, it is a law that was passed in 1890 as a federal law. Before that, in like 1887, 1888, 1889, you had each individual state form their own laws to go after companies, but they didn't really hold a lot of weight until the federal government came in, and John Sherman wrote this law, and he actually didn't like the law. He thought it wouldn't work, and at first it really didn't. It was sparsely used until, say, 1901, and even then, I think the law was applied to the U.S. Steel Trust. Carnegie, he won his case against the government. He clearly had a monopoly, but as I said before, there are certain monopolies that they don't touch because if they did break them up, it would cause more harm than good. I don't think that that's the case here. If Fanatics is in fact a monopoly, or aiming in that direction, even if you aim in that direction, just the appearance alone could be enough for the government to look into your company. So even if Panini has maybe one or two exclusive contracts, those are going to end. And what they said was that they will not, we're not invited to participate in bidding on contracts going forward. Now, there actually are laws against this as well, and I believe it is in the Clayton Act of 1914. So that's actually against the law, in fact, if you're preventing another company from bidding. So one company actually cannot interfere with another company's bid process. In this case, Panini is saying that they weren't included in the bidding process. They were prevented from bidding. And so this is actually in the 1914 Clayton Act. And again, there's three different sections to the Sherman Act. And again, going back a little bit to the Sherman Act, John Sherman did not like this law because he said, A, it wouldn't work. So it wasn't really well defined. And that was the biggest problem with the Sherman Act. And I think it may still be, which is one of the reasons why in 1914 the Clayton Act was passed to shore up and strengthen the Sherman Act. The case of Panini here is saying that they were not allowed to bid or prevented from bidding on contracts here was something called horizontal customer allocation, which is illegal under the Sherman Act. It's an agreement from competitors at the same level of distribution of a product or service that each will serve certain designated customers and will not attempt to compete for the business of customers allocated to a customer. So that's where the GC Packaging LLC comes into play, I think, between that company and Fanatics. And if Fanatics actually has the majority of the controlling interest in that company that produces Panini's products, that could be something that a court would look into or a jury. And I think what is interesting here is that this is, I think, going to be one of the very few or the first companies or cases that have to do with cards that is going to go up through a jury. And so, again, with a jury, you never know what's going to happen. It's not like just actually facing a judge. And you again have to have uh, a a jury that understands what is going on. Same with the judge too. So if you don't have either, if you don't have a jury that understands anything about sports cards or licenses, or a judge that says this is just sports cards and who gives a crap, right? So that's happened before, and again, that's one of the reasons why Johnny Myers lost his case in 1942 was because the judge did not understand that he was a person who had the right of privacy, and the judge said that he's an entertainer and he doesn't have the right to privacy. Obviously, everybody has a right to privacy, and even entertainers. So this is, again, where I say that you may have a great case on paper, but it's like the 1964 Phillies where they were like 18 games up and everyone thought they were going to the World Series because they had a World Series team on paper, but in practice they lost. They didn't even get to the World Series in 1964. Easiest analogy that I can make. But if you guys have read about the 64 Philadelphia Phillies, I highly recommend that you do so. Just because it looks great on paper doesn't mean it looks great in practice. So over the last couple of years, I've heard a lot of people say that corporations and companies are not afforded and not subject to the Constitution, not like you or I. However, that's not true. And Morrison Waite said in 1886 in his argument, Santa Clara versus Southern Pacific Railroad, which was a 14th Amendment case, he said that companies uh, they are actually subject to the Constitution and they have the same rights and privileges under the Constitution that you or I have. I think this has been kind of muddied up over the last, I think maybe 100 plus years, at least 120 years. Uh, you have in 1903, I think one of the first times where companies had to register their businesses under the Bureau of Corporations. And so that turned into the Federal Trade Commission, or got swallowed up into the Federal Trade Commission in 1915. It's been really kind of murky because a lot of people are saying, "Well, I'm a corporation. I have protection under the Constitution," and so this is actually a little bit different here. That what Panini is saying is that the company Fanatics is talking trash, uh, and it's hurting their business. The, they're disparaging the company. Panini's going to have to prove that this is actually what's going on. And there's three different sections to the Sherman Act. It considers the First Amendment, and so uh, both of these companies have First Amendment rights. And just like you and I have First Amendment rights, both of these companies have First Amendment rights, but it's a little bit different for corporations and companies. One company really can't abridge another company's free speech, but each court will consider whether or not that is the case. And actually, there are cases that have taken the First Amendment into consideration. And one of them is the Associated Press versus the United States, 1945. It's one of my favorites. Another one is Citizen Publishing versus the United States. That's from 1969, and that's a non-exemption of the First Amendment. Another one is Eastern Railroad President's Conference versus Nor Motor Freight Inc., and that's 1961. Commercial printing is protected under the First Amendment, but there is actually four different standards governing commercial speech. So it's going to look really interesting to see what happens here. Some of this I'd like to see the evidence for. I'm not saying it didn't happen. I'm not saying it did. I just don't know what they are talking about when it comes to uh, fanatics trying to abridge their freedom of speech or trying to stop it. I'm not entirely sure. Commercial speech must actually relate to lawful activity and not be misleading and to receive First Amendment protection. And the first corporations to have the First Amendment rights were actually upheld in 1931 and again in 1936. And then finally, I know this has gone on a little longer than I expected, but finally, they're talking about locking up player trading cards for all three major professional leagues for the next decade and 2 decades. And this is actually something that has been up with the 1962 Federal Trade Commission flavors tops, their exclusive major league player contracts. So I'm really kind of curious to see how this is going to play out, whether or not Fanatics has a legal case against Panini, or whether or not Panini has a legitimate antitrust case against Fanatics. Personally, I think there are some things that Fanatics has done which raises some pretty big antenna with the Sherman Act. And I've talked about this in another video with trying to get small businesses under their roof. So that could be looked into as well, I guess, or taken into consideration as well. I just don't know, but I am I am wishing that I was on this jury. So, guys, thank you so much. I really appreciate it for sticking around and listening to what I had to say about this. I'm sure there are other YouTubers and commenters on this particular subject. I would really love to get a lawyer's take on this. I know Paul Lesko has had a few things about this as well, but I would like to hear from a lawyer who does not collect sports cards. Again, I'm not a lawyer, and if you need a lawyer, get a lawyer, and do not represent yourself in a legal court case. Again, I always say this, but I'll say it again: is that if you think that you want to represent yourself, don't, because 9 times out of 10 you will lose your case unless it is airtight. And again, I got very lucky when I represented myself, but I would suggest nobody represent themselves unless you have a fool for a client. So, guys, again, thank you so much for stopping by. I greatly appreciate it. Let me know what you think in the comments below. I'd always love to hear what you guys have to say anyway. And until the next time, I will talk to you later. Bye.